This morning's docket. That is case number 99988, State of Kansas v. Cheever.
May it please the court. I'm Deborah Wilson for the defendant appellant Scott Cheever. Justice Ness, I'd like to request 2 minutes rebuttal time.
2 minutes is granted.
Thank you, Your Honor. The question before the court today on remand from the United States Supreme Court is the propriety of Dr. Michael Wellner's testimony regarding Scott Cheever's bad character and his first-person narrative, which purported to recite Scott's thoughts as events unfolded at Hilltop. The simplest approach to the question of the character evidence is to analyze it under state law, and that's where I'd like to start today.
Under 6447, is that where you're going?
That's correct, Justice Rosen.
Let me just ask, why can't character evidence come in independently of 6447, as it did in this case?
Character evidence did come in, what we might consider kind of the more classic character evidence, where Scott actually admitted to past bad deeds and even past bad behavior. However, what happened in this case was we had what I would call maybe the purest character evidence I've ever seen, where the state wasn't just presenting evidence of past bad acts and then asking the jury to infer that Scott Cheever had a bad character from those acts. They actually had an expert witness who took the stand in the guilt phase and said, basically, Scott Cheever is a person of bad character. And they did this without the statutory prerequisite under 447B. The prosecution is not allowed to introduce this type of evidence of the defendant's bad character.
What are you referring to? You're referring to the outlaw evidence? Or
Yes. Yes.
That was brought in the state's case in chief, wasn't it?
That's correct.
And it was through a letter in which,
yes,
and commented on by your client in both his direct
That's correct.
and cross-examination. Why isn't that evidence in? I don't understand why you can't comment on it.
That evidence isn't in for two reasons. Well, actually, I have to say that the cross-examination about those letters was fair game, because that was an uncompelled statement that Scott Cheever made about the events that day. So we don't have a Fifth Amendment problem there. However,
to clarify, you're saying the cross-examination of Scott Cheever was fair game?
With regard to those letters, yes.
Okay.
Yes, that was fair game.
I just want to make sure whose cross-examination you're referring to.
That's right.
Sorry
but then, when Dr. Evans testified about Scott Cheever's cognitive abilities and the effect of methamphetamine on his cognitive abilities, that didn't open the door for the state to then bring up outlaw. And that was, as I was going to say, Justice Rosen, I've never seen
I don't understand why not.
Because the state was using this evidence that was beyond the scope, of Dr. Evans' testimony, which was strictly limited to the effect of methamphetamine on his cognitive abilities, which had nothing to do with his personality, with his psyche, with all aspects of his inner life, if you will, that went way beyond the scope of the defense in this case. What the state has argued to you today is that the proponent of, well, let me start with the proposition that character evidence...
It just seems to me you're forgetting that your client testified. And isn't that within the scope of what the expert can testify, then talk about?
He testified on cross-examination. He admitted, well, and even on direct, he admitted to bad acts. But that did not open the door to an expert witness coming in and testifying. Not only is Scott Cheever a person who's committed crimes in his past, Scott Cheever is a person who is defined by his criminality. His personality can be defined in one word: outlaw. You know, this is what the state is basically arguing to you today, that, okay, we have no evidence, the defendant offered no evidence of his good character. I think we all agree on that. The defendant offered no good character evidence whatsoever. And the state is arguing we can offer bad character evidence to prove guilt without the defendant offering, which is contrary to our law, 6447B, without the defendant offering evidence of his good character because the defendant admitted to some bad acts. So what they are saying is even if you believe that Scott broached, or what I'm saying is even if you believe that Scott broached the subject of bad character by admitting to past bad acts, Scott never offered any evidence of good character, which would then allow the state to pile on with more and more and more evidence that he was basically a bad person.
In other words, it wasn't rebuttal.
No,
It was
he wasn't.
corroborating the defendant.
He wasn't rebutting anything.
And if that's true, how can it? I know we're way ahead of jumping to harmlessness, but how can it have a prejudicial effect if Mr. Cheever has already been talking about it?
Yes, and Justice Luker, I really think that's the real question for the court today, because clearly Scott offered no evidence of good character, which would allow the state to kind of pile on with Dr. Wellner's evidence. And also, I don't know if we'll get a chance to talk about the constitutional ramifications, but once again, as you mentioned, Justice Luker, Dr. Wellner wasn't rebutting anything. Scott admitted to bad character, and what he was doing was he was just piling on with more evidence that Scott was a bad person. So we're contending today that the constitutional error is coextensive with the violation of our Kansas evidentiary rule. But the question, I think, is harmlessness. In this case, the jury was tasked with determining Scott's state of mind when the shooting occurred. And the jury could certainly look at this evidence and say, we believe Scott Cheever acted with intent. We believe Scott acted with premeditation. But the jury could have also looked at this same evidence and conclude that Scott was addled by methamphetamine, that he was acting wildly in a panic without design and without purpose. Dr. Wellner's inadmissible testimony, and remember what he said? He said Scott Cheever is a person who admires outlaws. In particular, he admires outlaws who engage in fatal shootouts with police officers, and he wants to outdo them. So that's Dr. Wellner testifying. Not only is Scott Cheever a bad person, Sheriff Samuel's arrival at Hilltop gave Scott Cheever a chance to achieve some sort of personal goal. He was actually testifying to motive in this case. And this inadmissible testimony that he wanted to be an outlaw, that he had no remorse for the shooting of the sheriff. In other words, Scott Cheever was a very, very wicked person, was prejudicial, and it was inflammatory to the extent that the jury could not possibly give thoughtful consideration to the evidence that was offered in Scott's defense, the effect of intoxication on his ability to premeditate or form intent. Instead, this testimony that the jury shouldn't have heard would allow the jurors to conclude that Scott was just an evil person who was acting like an evil person when he shot the sheriff. And I want to go back a little bit to this idea that somehow Scott introduced this topic. Yes, Scott admitted. He admitted to some bad acts in this case. However, in this case, it was the state who introduced this topic of outlaw. It was the state that pursued this topic of outlaw.
Through evidence, through a letter that your client wrote.
Through evidence of a letter.
It's part of their case in chief.
Right, and I'm not complaining about that letter at all. As I've said, I think that was fair game. However, what was Dr. Wellner
So it's fair
rebutting?
game in what context? If it's fair game, it's fair game.
We're talking about Dr. Wellner's evidence. And let's ask ourselves...
Which he took into account that piece of evidence. Why can't he do that?
And he also took into account his psychological assessment, based on the compelled interview in this case.
Which the U.S. Supreme Court said is appropriate.
The
remand says for the limited purposes of rebutting the defendant's evidence. And
Correct.
And I guess that's what we're here talking about. What's the limited? But why isn't that included in what's rebutting the evidence?
Because as Justice Lickard pointed out, what was he rebutting? Scott Cheever never took the stand and said, I'm a person of sterling character. I have a peaceable nature. I wouldn't have committed these crimes but for the effect of methamphetamine. He never said that. He never put his personality or the content of his character into play in this case. And Justice Rosen, what the United States Supreme Court said in Kansas versus Cheever, what the United States Supreme Court said in the Buchanan case was that this sort of evidence is okay if it is limited to rebuttal. Which brings us back to the question again, what on earth was Dr. Wellner rebutting? The only thing placed in issue by Scott's defense with regard to aspects of his psyche, the only thing placed in issue by this mental status defense was the effect of methamphetamine on his cognitive function. Scott, as I've said, Scott never said, I'm a person of good character. And Scott admitted to a series of bad acts.
But isn't the fact that he has this outlaw persona an element of rebutting the fact that he was not acting under the influence of the methamphetamine, but was acting based upon his own character, really?
I think I'm going to, first of all, I would say it totally would have been okay if he had in any way ventured that way and said, that's not who I am. That's not that's not what I normally act like, but for methamphetamine. But remember, Scott never said anything to that effect in this case.
What was his explanation for the outlaw comment in the letter?
He said that he was showing off for his friends. He said he was showing off. Now, that's a little close. But he never went farther and said, that's not who I really am. I'm really a very peaceable person. He never said that. And Justice Lickard, I'd like to kind of answer your question. This kind of relates to scope with what the Federal Court of Appeals in Hawaii said about rebuttal evidence in these cases. In the case of United States versus Williams, here's what the court said. The government may rebut defendant's mental status defense, not prosecute based on the defendant's mental health. And what we see in this case, of course, is Dr. Wellner very ably talked about how methamphetamine didn't seem to affect his cognitive abilities. He gave a lot of effective evidence with regard to that. But then he ventured into Scott's psyche. And he ventured into Scott's psyche to prosecute based on his mental health.
Well, let me understand something. Dr. Evans testifies that essentially he didn't have the requisite ability to form premeditation because of his methamphetamine use, mm-hmm. his chronic, no doubt about it, his chronic methamphetamine use. And then how do you rebut that without saying, no, that isn't what it was this, which is essentially what Dr. Wellner did.
And you rebut it by saying, I saw, as Dr. Wellner very ably did, I saw no evidence that his thought processes were impaired. But as the court stated,
and then he described how they weren't. And essentially, I know he did it in a way you disagree with, but that's essentially what he did.
Right. No, but see, he went further. He said he wasn't impaired by methamphetamine, and I can tell you why he did this. And with that...
Why he was not impaired by methamphetamine.
He did say that, but then
he said why.
Right.
And he described the conscious steps that he believed your client took. And that's the competing theories here, isn't it?
The conscious steps that he took was appropriate. What wasn't appropriate is to say, I've rummaged around in Scott's mind, and I can tell you his motivation. And his motivation is that he was an outlaw who wanted to be a super outlaw. That's where he went too far. And that's where he got away from rebuttal. Because Scott Cheever never put his character into issue. He didn't put it into issue under our state evidentiary laws, as expressed in 6447B. And he didn't put it into issue for Fifth Amendment reasons by by saying, this is not who I am, this is inconsistent with my psychological makeup. Dr. Wellner wasn't rebutting anything. Are there any further questions? I see my time is up.
I'm not sure I ever heard an answer to how this was a reversible error.
Oh, yes. Because of the great, if you accept that Dr. Wellner should not have talked about Scott's character, his character disorders, outlaw, that sort of thing, you have to look at the effect on the jury's ability to fairly assess Scott's defense. And in this case, what Dr. Wellner's testimony did was it invited, and not only outlaw, but also, by the way, he's not sorry either, because that was part of his testimony too. That is going to divert the jury, of course, from considering Scott's evidence to giving thoughtful consideration to Scott's evidence that he was impaired by methamphetamine. Instead, this testimony would have just allowed the jurors to say, Scott is just an evil person, and he was acting like an evil person when this crime occurred. Additionally, as I've alluded to, it supplied Scott with a motive. And that, of course, went to support the state's theory that the crime was premeditated and that the crime was intentional. So it also supplied Scott with motive.
Thank you.
In looking at the error, what's the standard of review?
For our non-constitutional error, where we say it violated the Kansas statute, it's harmless if there's no reasonable probability that it affected the outcome of the trial. For the constitutional error, which we allege is coextensive with the state statutory error, it is the state has to prove beyond a reasonable doubt that this evidence didn't contribute to the jury's verdict. And I would kind of like to add, not only did the prejudice occur in the penalty phase of this case, it certainly occurred in the guilt phase, it certainly occurred in the penalty phase as well, where we have all this evidence of lack of remorse and a person defined by his criminality.
Any more questions? Thank you, counsel.
Thank you.
Mr. Chief Justice, and may it please the court, Stephen R. McAllister for the state of Kansas. I would ask the court that it affirm Scott Cheever's capital murder and attempted capital murder convictions. It is clear after the Supreme Court's decision that Dr. Wellner properly was permitted to testify, and he did not exceed the scope constitutionally or under state law of proper rebuttal.
Did the U.S. Supreme Court say that? If they did, why did they remand it to us?
I'm arguing that, Your Honor. The Supreme Court did remand it for you to look at that because they don't like to get down in those weeds sometimes. But what they said, they certainly suggested that much of what Dr. Wellner had to say absolutely was proper rebuttal. They did not find it per se inappropriate. And basically the complaints you're hearing about, I still have a hard time understanding part of this. If you want to focus on the outlaw, and I'll talk about remorse and others as well, where does the outlaw evidence come from? It comes from the letters he wrote. Letters that were introduced, and you've heard my colleague say she has no qualms with them being introduced. They were properly put into the trial. When do they get talked about? Cheever's direct testimony when his lawyer says, a monster wrote these letters, didn't they, Scott? And then he starts trying to explain, that maybe was how I thought then, but that's not how I think now. It's also in that same testimony, basically pages 77 to 80 of Cheever's direct, that they start talking about remorse. The state doesn't inject remorse into this case. Cheever does. So that's the first place it shows up. Now, they've also said no problems with the cross-examination by the prosecution of Cheever regarding the outlaw evidence. So it gets discussed again, and they have no problem with that. The next time it gets discussed is when his own expert gets up there, Dr. Evans. And it actually comes up in two ways with Evans, I want to make clear. if you look in the state's appendix, the original appeal, I think it's pages 23 and 24. Evans, this is direct exam of Evans, not even cross-exam. Evans is talking about Cheever's, he had that hand on the hot pot reaction. Basically, in his own grandiose, indestructible mechanism or way of thinking, he was going to shoot it out with the sheriff. And he's saying things like that, and then he goes on, it's almost like the showdown at the OK Corral. Well, he may not have used the word outlaw, but that's the kind of thing he's talking about, and that was direct exam. Then cross-exam, the prosecution asks him more questions about Scott's outlaw persona, if you will, and he testifies about that. They're not complaining about that. So why is it only finally when we get to Dr. Wellner, who's simply discussing evidence that they admit is properly in the case, that Cheever has talked about, that his own expert has talked about, now somehow it's this huge reversible error because Wellner talks a bit about the outlaw persona. I'd say a couple of things about that, Your Honors. First of all, if you want to find an error, it has to be harmless in these circumstances. I mean, this evidence was all over the trial. Wellner didn't inject this. And his discussion of it isn't very long. If you look at the testimony of the two experts, their testimony is roughly the same length. Wellner's a little bit longer than Evans, but not significantly. And they were talking about the same kinds of things. What Wellner was doing, and I think the point has already come out, is it would be sort of a silly, limited, unrealistic rebuttal. If the defendant comes in and says, you know, the only reason I did this was methamphetamine, I just couldn't understand what I was doing. And all the state gets to do is come back and say, no, it wasn't meth, period. I mean, that's their view. We have to stop right there. No, it wasn't meth. Well, that doesn't make any sense. The jury wants to know, well, if it's not meth, what do you think it was? And Wellner's a highly trained MD, lots of experience, said he spent 200 hours or so on this case, and he's looking at a variety of options. And I want to be clear about a couple of things he did not do that I think are in our brief clearly, but the defendant keeps asserting he did. He never said, this is because of antisocial personality disorder. He said, I thought about personality disorders as any good psychiatrist would, but he doesn't say, I diagnosed Scott as having antisocial personality disorder, and that is why I think he did this. He also...
Didn't he say everything about that?
Well, I don't think so, Your Honor. I think he said, I considered that as a possibility, but he never said, I diagnosed him, and he never said he's a remorseless sociopath, which I think you have to be careful. They throw that phrase around. I suspect that Dr. Wellner, sociopath has a very clear and distinct professional psychiatric meaning. He never called Scott a sociopath. And as far as remorse goes, again, the first remorse testimony is Cheever's own. When he starts talking on direct, and his own lawyer says a monster wrote these letters, and he says, well, that was the way I was thinking then, but that's not how I feel now. At trial, he was talking about remorse. So, Wellner didn't introduce anything into this case that wasn't already in play. And I would challenge them to, when you talk about the I testimony, which is also a complaint, let me set the context for what Dr. Wellner was talking about. He was looking at first, right before he gave that testimony, a report of Dr. Price, which is about a 5-page report, and it basically was testing Cheever's mental abilities in various ways. And importantly, one thing it was testing is something they call response inhibition, his ability to control his actions to make choices. And Price concluded, after testing Cheever, that he had an above average response inhibition. He was able to make choices. And all Wellner did was take facts that you can find them, every one of those things, somewhere else in the record, Cheever's testimony, Evans' testimony. He didn't say, I'm Scott Cheever, here's what I'm thinking. What he was saying was, Cheever's saying, after you've had Evans up there, saying no thought process. I mean, Evans was strong. He said Cheever couldn't make a decision. There was just no executive functioning.
Did Scott Cheever testify, for example, that things like, I'm suspicious of these people, I think that came through, I'm armed, I think there was evidence of that.
Yes.
Then the sentence continues, I don't threaten him, I'm not intimidating him.
I mean, I think that's fairly implied from his, I'm suspicious, but I didn't do anything. I had the guy on the couch. I sat down. I decided we're okay. That stuff is there. He's not saying I had it in for Sheriff Samuels and I was waiting and I was going to get him. He doesn't say anything like that. He's describing actions that Cheever took, by and large, that show what he's trying to counter is Evans' strong opinion that this guy had no decision-making ability. And he's saying, well, wait a minute, then why do you hide? I step back. I wait until he gets close. Why do you step back out again then and shoot him a second time when he's helpless on the stairs? What Wellner's saying is that just shows decision-making ability. It shows response inhibition. It shows he didn't jump out the window like the other guy did. He's not trying to say I'm inside Cheever's mind. And it was right after he looked at Price's report.
Well, when you channel someone, isn't that what you're implying, that you're inside their mind?
Well, Your Honor, I don't, he could have said it this way. What if he had said, he hides behind the curtain. He waits until the sheriff. He put it in the third person. He would have said the same substance. So, I mean, if the issue of using the word I is enough to cross the line, well, that's something the court can decide. But it's got to be harmless in any event, given the facts of this case.
Didn't this come up in Kleypas? The channeling and the impropriety of using that method? I seem to recall.
You have better recollection than me, Your Honor.
Anyway, there is some case law out there where we've disapproved of the method of channeling. Would you agree with that?
I'll take your word for it. I don't know the case law specifically, but if you say there is, I won't question you on that. But I would say in any event, again, it all comes back to it has to be harmless on this record. The complaint here, it's hard to understand why all of this can come in all throughout the trial, through Cheever, through the letters, through his cross-examination, through Evans, both on direct and in cross-examination. But suddenly when we get to Wellner, it's a constitutional error of some kind for him to talk about the very things that all these other witnesses and this evidence has already addressed. And the fact of the matter is, of the whole crew, Wellner is the most credentialed and the most thorough and the most thoughtful about what's going on. Evans basically was a pharmacist who was focused on, this is meth. Meth does terrible things to the brain. This guy couldn't understand anything he was doing.
Given how credible your expert was, can you parse the difference between harmlessness on the guilt phase versus the potential prejudice on the penalty phase?
Your Honor, I don't understand the separation. I mean, all the testimony, they suggest you could do just the sentence throughout. That doesn't make any sense to me because it was either properly admitted or not.
If we're talking harmlessness, we're assuming error.
But
so I'd like to just focus on the harmlessness.
Right, but the thing is, all the testimony occurred in the guilt phase. It wasn't directed. We didn't use Wellner in the sentencing phase, and in the sentencing phase, we had to prove additional aggravators, which we did.
Definitely.
They put on mitigation.
But the jury carries over the evidence. They don't.
Well, the jury carries over, but I don't see how there was emphasis that Wellner was somehow given in the sentencing phase that would sort of reiterate. And again, to me, it's harmless in both places. Because it wasn't, if it's harmless with respect to guilt, it's harmless with respect to the sentencing would be the state's view and my view.
Counsel, did the state not formally rely on the guilt phase evidence as part of its case?
Oh, I'm sure it did. I'm sure it did. But what I'm saying is that Wellner didn't come back. I don't recall that the state harped on Wellner's evidence in the sentencing phase and said, remember, Dr. Wellner said this, this, and this. I don't think that's part of the sentencing phase. And also I'd remind
Would you agree with me, counsel, that in the penalty phase is more about the character of the defendant as opposed to the guilt phase? The guilt phase really isn't supposed to be about character. It's supposed to be about whether the crime was committed.
Right, and there's two questions there perhaps, Your Honor. One,
that's very possible.
I agree that the sentencing becomes a very individualized determination. That's why the defendant gets to put on all this mitigation and people love him and so forth. And that's all about, do we choose this person to actually get the death sentence? I agree with that, but I also do not necessarily accept the premise that the outlaw discussion in this context on the facts of this case is necessarily quote, character evidence in the sense my colleague suggests. I mean, character evidence, so somebody tortures cats as a child, we think that's a bad person, that means they probably killed this person. I agree with her when she says it's about Cheever's state of mind. And I think what Wellner is saying is state of mind. Well, if it's not meth, then what is his state of mind? And part of his state of mind is his own admitted fascination with outlaws. And so it's really state of mind evidence. It's not trying to use prior bad acts sort of thing to prove he must have done this. It's both sides trying to say what's in his mind the day he shot the sheriff. So, you know, in that sense, I'd say character evidence probably is definitely much more in play in the sentencing, but I'm not sure what Wellner was talking about really should be viewed as character evidence. I think it's state of mind evidence.
And just so if I can summarize from my own understanding, your point about the rebuttal evidence is that the state is not limited to saying no to what the defendant said. They also are able, under both the Constitution and our statutes, to offer an alternate explanation.
And I think state law is very clear about that rebuttal can also be used to corroborate the evidence presented earlier as well as rebut, but just logically, now, I'm not saying there's not an outer bound. At some point the court could find maybe an expert just starts talking about stuff that nobody else has ever considered or brought in, but it just makes no sense to say, well, he says it's methamphetamine. All the state can do is say, no, it's not. Because if I think most people as a juror was sitting there, I'd want to know, well, then what? What do you think it was? If it wasn't meth, why did he do it? So I think it's completely reasonable that the state would offer alternative explanations. It's not meth, and in fact, the reason he did it were these other things that Dr. Wellner discussed in his testimony. And I don't think there's any case law, Supreme Court or otherwise, that says you have to be narrowly limited. You know, they talk about the Hawaii case, but the Hawaii case, it's district court opinion, pre-trial. They're trying to sort of, in the abstract, talk about if they put on an expert, what could the state say in rebuttal? It's not a case where the defendant has already testified and the defendant's expert has already testified. So now we see what all they're actually going to talk about. So the Williams case has really no value here in our view. I would remind the court that you do have an issue in this case that is a problem for the sentence, and that's what I would call the Gleason issue, the burden of proof on the mitigation. And just to be clear, the state is pursuing the Gleason case, will pursue it with the U.S. Supreme Court. But what I'm asking for today is not to revisit that. I assume you probably don't want to, although I'd be happy to talk about it if you did. But to affirm the convictions here at a minimum, because the rebuttal testimony is about the convictions. And it's within the scope, which is wide-ranging, has to be reasonably related, is what the federal case law, Supreme Court case law says. And all of Dr. Wellner's testimony was reasonably related to rebutting things that were already in play in this case. So unless the court has further questions, I'd simply ask that you, at a minimum, affirm the capital murder and attempted capital murder convictions. And I guess we'll deal with the Gleason issue, however that plays out.
Counsel, when Dr. Evans talks about what I would just call the outlaw syndrome and how that was his alternative explanation for what motivated Mr. Cheever here, the defense's reaction to that or ability to do anything with that information is limited to their cross-examination of this rebuttal witness. Is that right?
Well, it is, although they've already had their own expert up there saying, no, I don't think it had anything to do with that. I think it's all driven by methamphetamine. So, it's just a matter of order, but it's not that they didn't address the question and whether it was a factor. And certainly, when you get into Evans' testimony on cross-examination, which I haven't really talked about, that is perhaps some of the most damning. He's the one, not Wellner, who says, oh yeah, Cheever had this Billy the Kid persona. That was Evans. That came out of Evans' mouth, not Wellner's mouth. So, that's another final point I'd make, Your Honor, is reread, which I've read more than once, Evans and Wellner's testimony, they're not chock full of objections. There's virtually no objection by the defense to any of this as it's going along. It doesn't appear that they thought this was out of bounds at the time. This is all stuff they're trying to create later on. The objections don't go to, you can't talk about outlaws. I mean, sometimes it was the form of the question or something, but it was never about this. And they don't object when Scott's cross-examined on this territory. They don't object when Evans is cross-examined on this. And when they get their chance to cross-examine Wilner, mostly what they talk about is what's this group you work with and how much do you get paid to handle this case. That's the most of the cross-examination.
Very well. Do we have any further questions? Thank you, counsel. You reserve 2 minutes for rebuttal.
Thank you, Your Honor. There were objections. There was an objection to the prosecution's questions to Dr. Evans about Scott's character. Partway through the questioning, the objection was that those questions were beyond the scope of Dr. Evans' testimony, which they were, because Dr. Evans offered no testimony about Scott's character or his personality, but that objection was overruled. There was also an objection to Wellner's testimony that antisocial personality disorder, because the prosecutor did tell the judge, Dr. Wellner's going to say he has an antisocial personality disorder.
But he never did he? I mean, that never happened.
Right, just because I think the prosecutor forgot to connect the dots at the last, and he certainly
Wait. Just because they forgot or whatever, that was never offered by Dr. Wellner.
Right, only outlaw. That's what was offered. There was an objection that Wellner's testimony was, with regard to his psychological testing, was beyond the scope of the defense. That's on volume 27, page 62, before Dr. Wellner testified. Justice Johnson, I think the words you were searching for were imaginary script. That's what this court discussed in the Kleypas decision. The Supreme Court called it an extended soliloquy. I call it stream of consciousness. And what I mean by that is Dr. Wellner presented to the jury Scott's conscious thoughts as he perceived and reacted to events at Hilltop. The problem with this, and the thing that makes it so misleading and so prejudicial, is that he placed events in Scott's stream of consciousness as if they were occurring simultaneously.
Well, what about Mr. McAllister's point? What if that testimony would have been offered and said in the first person, in the third person, and just repeated it? Instead of I, it's he. He did this. And then he, didn't jump out the window. Then he didn't do that. Is there a difference?
Yes.
What's the difference?
The fact of the matter is, listen to what he said. He said, I don't jump out the window like my friend later does.
He didn't jump out the window like his friend later did. What's the difference?
Which he perhaps could have said, he didn't jump out the window, his friend later does. But what Dr. Wellner did was he put these two thoughts in Scott's mind at the same time. I don't jump out the window like my friend later does. That implies to the jury that he's actually considering two alternative courses of action. And part of his consideration is based on an event that hasn't occurred yet. And he does the same thing with regard to the shooting. I don't shoot just to frighten the sheriff like I do later when the deputies arrive. What he's telling the jury is that Scott was actually considering, should I jump out the window? We have no evidence that he was considering jumping out the window at that moment. Remember, his friend did that later. We have him implying to the jury that when Scott saw the sheriff, he was thinking, well, maybe I could shoot to frighten him, but instead I will shoot to kill him. There's no evidence of that. And even on methamphetamine, an individual can't reflect on an event that hasn't yet occurred, and that's what Dr. Wellner was telling the jury. And
is that fair, though, in light of how he started with that, when he was talking about executive functioning and response inhibition? Because isn't he saying, we know that he warns his friend not to jump out the window, so it's a consideration that he rejects. We know that at one point in this sequence of events, he chose to frighten someone rather than shoot them. Isn't he just contrasting two different decisions that Cheever made?
It might have been appropriate if he had done that, but that's not what he did. He put these things in Scott's consciousness together as if he's calmly deliberating about two alternative courses of action. That is not based on facts that we can glean from the record. I mean, yes, we know that someone jumped out the window later, but we can't assume from that Scott was considering, oh, I'll jump, no, I'll stay and shoot the sheriff in this case. What he was actually doing was he was offering argument. He was making the prosecutor's argument. It would have been fine if the prosecutor had said, you know, Scott could have jumped out the window. His friend did later. He said he could say Scott could have shot to frighten instead of shooting to kill, which is the prosecution's point of view of this. That's okay because that's argument. And the jury is told that's argument. In this case, we have Dr. Wellner, as everyone has mentioned, highly credentialed, smarter than everybody else in the room, who knows more about this stuff than everybody else does, telling the jury Scott was considering these options. And that's not based on facts. That's not based on facts. And that's why it was so prejudicial in this case and wrong.
Any further questions? Thank you, counsel.
Thank you.
We thank both of you for your arguments this morning. Clerk will take this matter under advisement.